Good morning to all of you. Today it has been published in Hindu that the agrarian movement is being stifled by maybe the government of India with the fuzzy law, unclear jurisprudence and the trampled rights. Since we have been dealing with the topic jurisprudence, better to know why it is unclear, why they have called it as unclear jurisprudence. Before that, better to apprise you of the incident for some time. You may be knowing the formulas, they have created confusion or they have created terror in the minds of the agriculturists, particularly in the northern states like Punjab, Haryana and Uttar Pradesh. And the agriculturists, they want the repealment of these particular three laws. They want these three laws to be deleted at any cost. Of course, the government is there. They are asking, they are requesting, even at the level of Prime Minister Narendra Modi, he has been requesting them to come and have a dialogue. So of course, since 10 times the dialogues have been failed, but still the government has opened the gates for the dialogues. But still these agriculturists, they want the repealing or the deletion of these laws. So in meanwhile, no doubt they are doing it in a very systematic and a democratic way. In a democracy, maybe knowing dissent is definitely a very good form of democracy. But the incidents on January 26th, it created chaos in the capital city of Delhi. So who is that man going to the top of the Qutub Minar Red Fort? Not Qutub Minar, going to the Red Fort and using that hoisting that flag and other things, it has created definitely a controversial topic. And in this connection, now we are coming to our topic, the social media platforms like Twitter. Of course, every politician, they have got Twitter accounts. So some Twitter accounts, they have been suspended partially, right? So particularly certain magazines like Caravan magazine, actor Sushant Singh and many other people, their accounts have been suspended. Of course, we got a doubt that may have been suspended due to the public policy of the Twitter. They might have been governed by under Section 69A of the Information Technology Act. We were thinking like that. But after some time, Twitter reopened their accounts and now they employees of the Twitter, they got memoranda from the government of India. Yes, a meeting between officials and government appears to have yielded of no result. Right. Anyway, since the accounts of the politicians, journalists and so-called very good public activists, they have been reopened, but the government has served a memo on them using the powers under Section 69A of the Information Technology Act. You may be knowing this 69A has come into existence by the amendment of 2008 for the IT Act 2000. According to 69A, if the central government is of opinion that in the interest of sovereignty and integrity of India, and secondly, defense of India, thirdly, security of the state, and to maintain the friendly relationship with other states and are in view of the public order, right, or preventing incitement to the commission of any offense. In such circumstances, the government can order the so-called intermediaries, because Twitter, Facebook, Google, all these, they are called as intermediaries in the IT Act. Yes, to publish or to restrain from publishing, to add the account, to delete the account, all these things they can do using the powers of 69A. Now they're clear. So even though jurisprudence says that you have got a right to speak, because it's, of course, even though the Constitution says it's a fundamental right, but law gives us rights, duties and obligations also. So even though you have got a right, now let us say it's a constitutional right to speak whatever like, you may be knowing, according to Article 19 also, there is the so-called reasonable restriction. So reasonable restrictions are there to control, otherwise you will be losing your tongue. Here what happened is, since there is a hashtag that Modi or Prime Minister going to see that genocide is occurring to the agriculturists. This is the hashtag, and whoever is forwarding this tag, they have been arrested and their accounts have been being suspended. Very recently, one a public activist by name Disha Ravi, I think she is yesterday she has been arrested from her Bangalore because she has forwarded the message of Greta Thunberg, who is a climate activist. All these things are happening. So, what is the use of this jurisprudence? Even though jurisprudence says that the law should give a right, that too, an absolute right for free speech, but still there are so many hurdles or so many hurdles for them. This is one problem. Second is fuzzy law. So, law itself. So, while discussing the great judgment, Shreya Singhal versus Union of India 2014, then Justice Almeshwar, Rohinton, Nariman and others, they held that Section 66A is against the Constitution, spirit of the Constitution. That is also free expression. Second, actually they have discussed that 69A, but it has somehow been it has not seen the light. They should have discussed and they should have written at length about that 69A also, because if at all there is any threat to the security of the nation, definitely the central government is competent to put a ban or to embargo on the intermediaries. But for each and everything, they cannot do like this. This is the main problem with the legislature at present, because unbridled powers were given under Section 69 of the Information Technology Act. So, another very recent, this internet ban, Kashmir internet ban. This is also another problem. Even the agriculturist sides also, when they decided to take a rally or something later also, they have banned the internet in the particular area, that Singhu, Tikri and Ghazipur areas, they have banned. Of course, using the powers and the provisions of the Wireless Telegraph Act 1855. So, law is there, jurisprudence is there, but still the rights are being trampled. This is the problem being expressed by the intelligent people, particularly in the media. So anyway, it is for the government to react or not. But as far as we are concerned, as jurisprudence topic, we have to see that the jurisprudence, why? Jurisprudence is the theory, law is the application. So jurisprudence is nothing but the development of law, or the skill in law, or the knowledge of law. So the jurisprudence should definitely be clear about the rights. That means the rights, of course, everybody will take advantage of the lacuna in the law. That's why otherwise we can't survive as advocates also. But anyway, so we here what they want is the jurisprudence. The jurisprudence dentists or the thoughts definitely should reflect on the correct rights, and the rights of the citizens should be protected, but the government should not resort to Article 69A, Article 60, Section 66, Section 69A, Section 66A and Article 19 clause to reasonable restrictions unnecessarily, haphazardly, wherever there is no necessity. They can utilize the legal phraseology wherever there is necessity, but unnecessarily they should not do. This is what is all meant in this article in the Hindu. So please go through it and enrich your legal knowledge, particularly the unclear jurisprudence. Thank you very much.